Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to talk about a very important topic that a lot of you like to talk about, so let's talk about it, and that is standing. So today's presentation is about standing, who really has the right to foreclose. Okay, so we're going to talk about one of the most misunderstood concepts in foreclosure law, standing. You probably heard people say things like, they don't own my loan. The assignment was robo-signed. They charged it off so they can't foreclose. Show me the original note. And while those statements sound powerful, the real legal issue is much more precise. Standing simply means this. Does the party trying to foreclose have the legal right at that moment to enforce the note and the mortgage? That's it. It's not about whether the bank is moral. It's not about whether securitization was fair. It's not about accounting entities like charge-offs. It's about enforceability under contract law and the Uniform Commercial Code. In a judicial foreclosure state, the plaintiff must be able to show that they had the right to enforce the note when the lawsuit was filed. In a non-judicial state, the question becomes whether the party directing the trustee had lawful authority under the deed of trust. Now here's where most people get confused. The company collecting your payments is usually the servicer, not the owner. The investor might be a trust. The trustee conducting the sale might be a completely different entity. Servicer does not always equal owner, and owner does not always equal trustee. And not every defect in paperwork destroys standing. Some assignment issues matter and some don't. Timing often matters more than appearance. Standing is a technical issue and is timing sensitive. And when it works because the foreclosing party cannot prove enforceable rights at the time foreclosure began. When it fails, it usually fails because the borrower relied on internet theories instead of legal standards. We're going to look at today what standing actually requires, when assignment defects matter, how trustee substitutions come into play, and when standing arguments realistically succeed and when they don't. If you understand standing correctly, you can evaluate a foreclosure case strategically instead of emotionally. Standing, who has the right to foreclose? First of all, standing is a threshold issue, meaning it must exist at the moment the foreclosure action begins. It is not something that can be created retroactively after the case is filed. In a judicial foreclosure, the plaintiff must have had the legal right to enforce the note and mortgage on the date the complaint was filed. If standing did not exist at filing, later assignments or endorsements generally cannot cure that defect. Courts analyze standing first because it goes into the fundamental question of whether the plaintiff has the legal capacity to invoke the court's authority at all. Without standing, the case should not proceed regardless of the merits of the default. Most homeowners assume if they send letters, they own the loan. If they service the loan, they can foreclose. If the loan was charged off, the foreclosure is illegal. These are assumptions, and all three can be wrong. What standing actually means. Standing equals a legal authority to enforce the note and foreclose the security instrument. In most states, the foreclosing party must show, number one, they are the owner or holder of the note, or number two, they are acting on behalf of the holder, and number three, they have authority under the mortgage or deed of trust. And this comes from contract law and the Uniform Commercial Code, or the UCC principles. Standing is about legal enforceability, not fairness. Standing is about the legal enforceability, not fairness. The court is not asking whether this situation feels unjust. It is asking whether the party seeking foreclosure has the legal right to enforce the note and security instrument at that particular point in time. Much of the confusion comes from misunderstanding the key players involved. The original lender is the company that made the loan. The note holder or investor is the party that ultimately owns the debt and has the right to enforce it. The servicer is the company that collects payments and manages the account, but often does not own the loan. In non-judicial states, the trustee is the neutral party authorized to conduct the foreclosure sale. Neutral being key, guys. And a substitute trustee may be appointed to replace the original trustee. MERS, which is Mortgage Electronic Registration Systems, may appear in the records as a nominee or beneficiary for tracking purposes, but is not typically the actual owner of the debt. Homeowners frequently mix these roles up, assuming that they are all the same entity, but they are not. A servicer is not necessarily the owner, and the owner is not the trustee, and the trustee is not the beneficiary. Understanding these distinctions is critical to understanding standing. When a servicer files foreclosure, it must either be the holder of the note or be acting with authority from the holder. The authority must be shown through a servicing agreement, a power of attorney, or business records. The key question isn't whether they attach the documents on day one, it's whether they can prove the authority when challenged. If the original lender no longer exists and the note has no endorsement, that doesn't automatically void the foreclosure, but it does raise a critical question. How did the foreclosing party acquire the right to enforce the instrument? If they cannot prove transfer through admissible evidence, standing can become a real issue. The absence of endorsement shifts the burden to proving a valid transfer. Assignment defects. What actually matters? Homeowners often focus on assignment issues such as late transfers into securitized trusts, robo-signed documents, gaps in recorded chain of title, assignments recorded after the foreclosure complaint, minor errors in entity names. But here's the critical distinction, guys. Not every assignment defect destroys standing. Courts generally separate assignments into two categories: void versus voidable. A void assignment conveys no rights at all, which is what you want for your assignment to be, by the way. A voidable assignment may have technical defects, but still transfers enforceable rights unless challenged by a proper party. Most borrower challenges fail because courts view many assignment problems as voidable, not void, meaning only the parties to the assignment can complain. When assignment defects can create standing problems, on the other hand, let's talk about that. A more serious issue arises when the assignment was executed by an entity that no longer existed. The assigner had already transferred away its interest before the assignment date. The entity signing lacked corporate authority, or the assigner had nothing left to convey at the time of transfer. In that situation, the legal problem is not a paperwork error. It is a question of whether the assigner had any rights to transfer at all. If an entity does not exist on the date of assignment or has already divested its interest, there may have been nothing to give, and if nothing was conveyed, the assignee may lack enforceable rights. This is not a cosmetic defect. That goes to the core of standing. In New York, the plaintiff must have the note before filing, and they must strictly comply with statutory pre-foreclosure notice requirements. If they file before acquiring the note or before the 90-day notice requirement is satisfied, the case can be dismissed. Now, trustee substitutions in non-judicial states. Let's talk about that for just a second. Common questions. Was the substitute trustee properly appointed? Was it recorded before the sale? Who had authority to appoint the substitute trustee? This matters because if the wrong trustee conducts the sale, that can create a procedural defect, but again, minor technical errors rarely void a sale unless prejudice is shown. Judicial versus non-judicial context. In judicial states, standing must be proven in court. It is raised early through a motion to dismiss or a summary judgment. In non-judicial states, standing disputes usually arise post-sale. Relief often requires an injunction before the sale, and the procedure changes strategy. So some practical advice for homeowners: if someone's facing foreclosure, look at the complaint filing date. Compare it to the endorsement dates. Review the assignment timing. Verify substitute trustee authority. Focus on material defects, not internet theories. And most importantly, deadlines matter more than arguments. Standing is a real doctrine, a technical doctrine, a time-sensitive doctrine, and it is not a magic bullet or a universal defense or a YouTube trick. The key question isn't, did something look wrong? The key question is, was it legally insufficient at the moment foreclosure began? And as I said about New York, it is known for taking standing very seriously, and the foreclosure party must demonstrate it possessed or was assigned the note before filing the complaint. And so, in addition, strict compliance with statutory pre-foreclosure notice requirements is mandatory. And so if you're in New York or you're in a judicial state, you need to look at all those pre-foreclosure notice requirements that must be followed as well, because a lot of times they are not. And you can kick out and get a foreclosure dismissed just by saying that, or going over that and saying they failed to comply. Anyway. By contrast, some states like Florida also require standing at inception, but courts are often more flexible in how it is proven. As we know, Florida is known as the rocket docket state because judges like to get foreclosure matters out of their dockets and courtroom in a quick manner, whereas New York can sometimes take years. Okay, guys, I hope this was informative to y'all. And if you have any questions or comments, you can leave them below. And thank you for subscribing if you have subscribed. And you can always send me an email if you have any questions. My email address is right here, foreclosurehelp777@gmail.com. And as always, everyone have a blessed day.